Hi, everyone. Harry here to talk about the case of Vance Boulder, the 57-year-old man who assassinated a Minnesota state legislator and her husband and seriously wounded two others and had a long list of people that he was hoping to target or kill, most of whom seemed to be legislators that have some pro-choice views or role in policy. And the sort of headline of today that the courts and newspapers are tumbling to is the distinct possibility that he, Boulder, will be subject to the death penalty. Notwithstanding that the death penalty is long since been outlawed in Minnesota and hasn't been used in over 100 years, and that during a botched execution. And it's really the reason that it could happen that I think is the most important part of this story and that I wanted to detail. All right. Why, since Minnesota outlaws the death penalty, might Boulder be subject to it? Because of federal charges and federal authority to impose the death penalty, and that's in rare cases, but his case as charged looks like it qualifies, because when you commit murder with a firearm, or potentially when you commit murder and you have a sort of terrorism kind of agenda, the affidavit here to hold him from the FBI agent came out of the box with this being a political crime and an ideological one. The federal death penalty statute kicks in. Now, that's just the beginning of this story, and the important wrinkle is one that I think the papers, by and large, and media haven't tumbled to. And that is, when there's a case, such as this one, that could be brought in the federal courts or could also be brought in the state courts here, Minnesota, there's a policy in place at DOJ. It's called the Pettit policy, after the case that gave rise to it. And what it basically says, and let me note that I worked quite a bit on this when I was at DOJ. It says, first, the presumption was for the state to go first. Basically, what the Pettit policy is about is just a sort of weighing of the two sovereigns' interests in having the case. And you think about this one, sure felt and looked a lot like a Minnesota kind of murder on the streets in the home of state legislators, not federal ones. And so while you can make a federal case out of it, you typically would do that only second. By the way, let me take a step back and make the strong, important backdrop legal point. Sure feels a lot like double jeopardy if he could be convicted first in federal charges and next in state, or vice versa. But the Supreme Court has held that the federal Constitution doesn't preclude convictions on the notion that two different sovereigns, federal government is one sovereign, the government of Minnesota is another, and for these purposes, it could be like the federal government and the government of Brazil, whatever, a different sovereign imposing a different penalty. Okay, so that's how you even get the situation that the Pettit policy governs. But here's the way it governs it, and it's very well established, and it looks as if the Trump administration and DOJ is just completely leapfrogging it and bulldozing it. State goes first. The assumption is the state has the stronger interest. And if you make the analysis here, the state does have the stronger interest, right? It's really more what happened on the ground in Minnesota as opposed to some national interest that this guy's murder implicates. There are other cases, maybe the Unabomber say, murders are all over the country, and they have this sort of broad national kind of ideological motivation. here, this really seems like Minnesota's kind of lookout. And again, the policy says you leave it to Minnesota first. All right, and then Minnesota takes its turn, and it does the best it can, and it imposes, presumably, life without possibility of parole, although they have to, for holding purposes, just issued a charge of second-degree murder. This would clearly be first-degree murder. Under Minnesota law, the distinction being premeditation, and this guy has, premeditation for days with the constructing of the lists, and it's a very plainly premeditated murder. So what the feds always would do in the past is wait for Minnesota to play it out, and then they would make their determination is something about what Minnesota did and the way things went down there. Does something about it leave the federal interest in the case demonstrably unvindicated? That is the sort of two words, and I can tell you they were very hotly negotiated within the Department of Justice and different divisions. But you can see the idea. The feds have an interest in certain cases. Here, it's a little bit unclear what the interest is. It may be a general interest in imposing the death penalty as their legislative representatives have passed, as opposed to Minnesota. But in any event, what the question would be, was the interest demonstrably unvindicated? Take a case like the Rodney King case, where there was an acquittal at the initial state prosecution. Then you can really say, and the feds really did conclude, our interest here, and we have an interest here because it's the federal constitutional rights that were involved when the officers beat Rodney King, was really left demonstrably unvindicated. We have a right, and we're going to exercise that right to come in and do a federal re-prosecution, which is actually something that I worked on. Okay, but so here, what seems to be happening is, when it first came up, what did Donald Trump, the president, do? He totally trashes Governor Walz, the governor of Minnesota, calls him, whatever sort of Trump's limited vocabulary reaches for, but it was one of those. And it looks to me, we don't know the inside path yet, but it looks to me like the feds are simply, just pushing Minnesota out of the way. And why might they do that? Well, first, it's better to be first. If you are second, even though that's the position the feds often put themselves in, the defense already has the benefit of this prosecution case. It's a lot easier for them to defend. That is for starters. Second, there might not be a second trial here. There's going to be a high profile first trial here. And just for, base reasons, the feds might want to come in and grab the glory and do the case, and Trump can, extol it and talk about it. And remember, Trump has said he's ordered the Department of Justice to seek death penalty cases. So this would be one. And if they get the death penalty, just for raw PR political reasons, the feds have their practices kind of focused on and burnished and the like. So, of course, that's the exact opposite policy or preference as the state would have, because if the state goes first, as happened, very good example, especially because it was in Minnesota, the Chauvin case, right? The officers who beat George Floyd to death. That was a federal case, and the feds, as they often do, file charges just so they are there and then in a placeholder way, and you can see what happens. But they wouldn't bring them until after the states do. So the headlines out there are, a murder case in Minnesota may be subject to the death penalty. But the important part of the analysis is why, and the why is because we may learn a little bit more about this, but it seems as if the feds just were able to just basically leapfrog, gave an order to bring Boulder to the federal facility where they did it very quickly. And he made his first appearance in federal court. So maybe there'll be a fight, or maybe Minnesota will just capitulate. But I believe what has happened here that makes the death penalty more likely. Although again, they could always, if they don't get the death, they wouldn't get it in Minnesota. The feds could always come in after in order to seek it. But in any event, what's happened here is really a transgression of a norm, not a law, as so much of DOJ practice is. But you would have expected the feds to maybe file charges, but then take a back seat, maybe help if they can. And then if and only if the Minnesota prosecution leaves the federal interest demonstrably unvindicated, would they be coming in and bringing their own charges and potentially seeking the death penalty. So here, it doesn't look so nice and pretty and cooperative to me. It rather looks like just from the outside, and that's all I am. I think we'll learn more, but from the outside, the feds having wrested it away and taking it first seems to me like they've just haven't applied the long-standing Pettit policy that they are supposed to. It doesn't give any rights, but the feds are supposed to do it. It's just one more instance of an abrogation of norms by the Bondi Department of Justice. And probably, although the initial charges were announced by an acting U.S. attorney who, to my ear, sounded like a sort of professional, long-standing person in that office, I think it's the kind of case that if the feds successfully wrest it away, will be taken over by the political stratum of people within the Department of Justice. And their avowed lookout in doing this in any case is, how does it look? For Donald Trump. And so for Trump to get the credit for providing the death penalty for a heinous defendant whom the whole country knows requires a change to normal DOJ procedure. And I think that's what we're seeing and what has happened. We ought to know within the next week or two that it ought to sort of leak out what's going on such that the feds have initial control of the case. And will they just, as a factual matter and a matter of just straight political leverage, be able to keep it and go first, even though Minnesota would prefer to and normally would. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.